Highland Council is walking into a known legal risk. The Court of Session has already ruled in Muirhead that Section 26B cannot be applied retrospectively to require planning permission where the change of use happened before a control area was designated. The danger is that Highland could recreate retrospectivity through the back door. The Council says the new control areas are a future-looking tool to manage future changes of use. And yet its own report says that existing operators renewing licences will have to demonstrate their planning permission. If licence renewal becomes the trigger for reopening historic planning status, that is exactly where the legal vulnerability lies. Senior counsel has already warned that reversing the burden can be unlawful. James Finlay KC advises that there is no statutory onus on a short-term licence applicant to prove the planning permission, including under mandatory condition 13. He further states that imposing such a burden without statutory foundation would be unreasonable. There is a direct litigation risk if Highland gets this wrong. James Finlay KC considered a similar approach in Edinburgh and concluded that either imposing the onus on applicants or continuing to act as though control area rules were retrospective would be clearly unlawful in a public law sense. Councillors should ask why they are taking that legal risk when the existing Highland control area has not been shown to work. Highland Council's own information has not demonstrated that Badenoch and Strathspey has improved housing affordability or delivered a measurable housing benefit. There was no formal effectiveness review, no defined success metrics, and no comprehensive economic impact assessment. The consequences of a bad decision are not theoretical. Existing businesses could be pushed into planning applications or certificate of lawfulness applications costing £742 per 100 square metre plus fees, assessed under policies that did not exist when they started trading, and potentially they would be forced to close. That raises not only judicial review risk but also proportionality and property rights issues under Article 1, Protocol 1 of the Human Rights Act. Councillors need to understand that this is not just a planning policy choice. There is a real risk Highland Council could end up defending in court an approach which the Court of Session has already warned against.